Hi, it's Billy Tarasio from Modern Law, and today I'm going through a bunch of questions that have been sent in. And if you have questions, you can send them in as well, because I like to have a video library that really answers any questions that you might have about Arizona law and family law and how it affects you in Maricopa County and Mesa and Gilbert and Scottsdale, wherever you might be located. So the first question is a great question. In Mesa and in the state of Arizona, are the laws governed by community property or an equitable distribution? Is it a community property state or an equitable distribution state? This is a great question. So, all states within the country are either community property or equitable distribution, and it does have a very big difference. And there is a big difference between how property is divided from one state to another, and sometimes from county to county or courthouse to courthouse. There's what the law says, there's what the local rules say, and then there's how judges typically behave, which is why it's important that you get somebody who has the local knowledge of a lawyer who's practicing in the area where you are getting divorced. And so to answer the question, Mesa and Arizona are a community property state. What this means is that when a couple gets married, a community is created, and the community, everything that one spouse does, they do on behalf of the community. So if your spouse buys a car, the community bought a car. If you go to school and you get school loan debt, the community has technically gotten student loan debt. Um, if you go buy if you go buy furniture and you put it in your house and you get it financed, the community is liable to pay back the furniture company for that financing. In an equitable distribution state, that means you're a separate property state, and it doesn't necessarily work that way. In an equitable distribution state, if I go out and I buy furniture and I put it in my house and I finance it, I am responsible, but not necessarily my spouse. So there is a big difference there. But when you're getting divorced, an equitable distribution is required in both the community property state and a non-community property state. And an equitable distribution in Arizona is an equal distribution of property, meaning the same amount of money. So if the community is worth $100,000, generally each person should get $50,000 worth of property. It doesn't mean that you have to get half of the equity in the home and half of retirement. One person could take all of the retirement, somebody could take half of the home or all of the home. You can offset different types of property, but the overall distribution has to be roughly equal. Now, here's where things get really interesting. What about pets? People love their pets. Are pets property, or are pets more like children and subject to custody laws and the best interest of the pets? Well, in California, pets are treated more like children. And the question is, what's in the best interest of the pets? In Arizona, pets are property. And that means they're subject to community property rules. That means if your pet was purchased during the marriage by either of you. Let's say you went out and you bought this pet, and this pet has been yours the whole time. Well, it technically belongs to the community, which means which means it's subject to equitable distribution. So that means essentially you have to put a value on this, and then, generally speaking, if a couple is fighting over a couch, the judge might say sell the couch and split the money. You're less likely to do that if you're talking about a pet. A pet has value way beyond the value that it is sold. It is more like a child, or more like something between a couch and a child. So the laws and the reality don't really line up, because I've never seen a judge who said sell your pet and split the money or cut it down the middle, like that biblical story where they talked about cutting the baby in half. No, we don't do that, thankfully. So it is a value item that would be on one, either allocated to one spouse or the other spouse. What factors are considered when assessing the value of a companion animal? Well, I mean, what the interesting thing about pets is that pets are also a cost. And so a lot of times, or many times, a couple will fight over who has to pay to care for the pet. Pets can have medication needs, food needs, grooming needs. It can cost hundreds of dollars a month to take care of pets. And most of the time, or many times, a couple treats a pet more like a child than a piece of property. Couples come up with agreements to share custody, to share expenses of pets. But most of the time, those are kind of unenforceable, or they would never be ordered by a judge. Now, if you agree to this, then it will be enforceable. So if you agree in a property settlement agreement or in a consent decree for divorce to share expenses and to share time, then it will be a binding contract that the two of you are held to. What factors are considered when assessing whether or not someone is a companion animal or emotional support animal? Well, this is a great question, but one of the things that I have advised clients in the past is if sometimes people can use a pet as leverage. One party is much closer to a pet than the other party, but the party who is not closer to the pet knows how important it is and can try to use that as leverage, can try to make a claim to the pet. And so sometimes I will recommend that the party that's closer to the pet go ask a physician for a prescription to have that pet become a emotional support animal. At that point, your ownership, claim, I think, goes up in the eyes of a judge, because if we're saying that this is that the animal is part of what you need medically, then it's I've never seen a judge say, well, you can't, too bad, so sad, you have to split the dog, or he gets the dog, or she gets the dog. So something to think about if you are really anticipating a fight, and if you don't think it's best for that animal to be divided and shared between the two of you, you might consider getting an emotional support animal. Or the other time that this has come up is when the couple bought a dog for their child, and their adult child was the primary caretaker for the animal, but it's technically the community property of the spouses. So in that case, again, I recommended that the mom take her adult daughter and go get a prescription for the adult daughter to have that companion animal. At that point, what we could argue is that the community made a gift to the child. So it's so interesting when we try to put together property law, which is gifts and community and inheritance and that sort of thing, intent, and when it was purchased and with what money, and we couple that with the emotional implications of pets. So it's something that, if it's a really big issue to you, you might want to consider talking to an attorney about your specific situation. If an animal is officially a companion animal, but it fills an emotional support role to one of the parties, how might this be addressed? That's the question I was just answering, where I really think that if you have a companion animal or an emotional support or something like that, that it is much more likely that the person who has that animal will receive the property, the animal, and the expenses that go along with the animal. So that's something to think about. In the realm of divorce law, are pets considered assets or liabilities? That's a great question, and it's kind of what I was just talking about, where they're both. They're a liability because they require care and support. You're never going to get child support for your pets unless you agree to it. And sometimes I do see couples agree to split the costs, or one party is going to keep the animals, during these months and the other during these months, or one party is going to keep the animals until the other person has a housing situation where they can take the animals with them. Really, whatever agreements the two of you come up with will be honored. And if you're fighting over the pet, then you have to get real creative, and you need to be thinking about the laws of community property and gifts, and perhaps getting a prescription or some sort of designation that your animal is an emotional support animal. What are the arguments against being pets classified as general property by the law? Well, a judge would never order that a table be shared between a couple. And I have seen judges order, when the parties agree that pets should be shared. And then you've got, states like California that have even made that law. And it makes a lot of sense. It makes a lot of sense when you've got, an animal who's attached to both parties, that you would think about sharing that animal. In my case, I'm divorced, and we've got 4 kids together and a golden doodle. And the golden doodle, her name is Lila. You've probably seen her in a lot of my videos because she comes to work with me. And when I first moved out of my house, when we were separated, we didn't have any sort of pet custody arrangement. And I was frankly more worried about making sure that I had access to the kids than the dog. And so at first I didn't have the dog at all. And she got ill. She wasn't doing well. She was really stressed out. She missed going with the kids. And then eventually we agreed that she would go back and forth with the kids. And that's been so great for her and for the kids and for me. So I am a big fan of when parties can work it out, figuring out a way to maintain relationships for the animal, with both parties and for both parties who, because I believe that pets are a really wonderful thing, and they increase our quality of life, and they help us, and they bring so much. I know Delilah, my golden doodle, brings so much to modern law. You know, she is an emotional support animal for every single person who works in my office. And when people come into my office, it's a divorce firm, and when they're stressed out and they're unhappy and they're emotional, and you've got this adorable, sweet, compassionate golden doodle who can just feel your energy and comes over and just brings a lightheartedness and a comforting nature to the situation. It's a great thing. And I think the more that we can allow our pets to share that gift, the better. So that's my personal opinion. But pet custody is one of the hardest things. And I understand how hard it can be for couples. And in some ways it's harder than kids, because kids have statutes. With kids, we've got a law. We've got case law. We've got statutes. We know what to do. And with pets, we really don't. We have their classification legally as property, which is completely inadequate to actually deal with what our pets mean to families, to children, and to couples that might be getting divorced. So I wish you the best of luck when you're handling your pet custody issues. And if you have questions that we can help with, please let us know.